I know this is a pretty sophisticated crowd. You've had quite a bit of this. I had planned on getting into a lot of the legal aspects, but you probably know all that. But I see a few new faces out there and folks that maybe are a little new to this whole area. So I do want to take a step back on some of these things. I'm just going to pause on a couple of things given the time that we have. But let me tell you a little bit about my background. So I'm a Silicon Valley lawyer. My main office is down the street in Menlo Park. We have offices in LA and San Francisco, but it's a little different market here. And it's kind of funny, just this morning, somebody asked me, they said, gee, do you ever, and all we do is technology startups. And somebody asked me, they said, do you ever invest in any of your clients? And I said, oh, rarely. I see so many companies. I see at least 3 a day. So before I'll invest in one, it has to be a sure thing. I will only invest in sure things, and that's when I invest. And they said, well, how successful have you been? I said, do you ever make any money on those? And I said, hardly ever. Hardly ever. That's kind of the nature of startup investing. It's so high risk. Now, when they do hit, it's a spectacular hit. It's incredible. And I could tell you stories that would probably blow you away. But the point I'm making is that this is a really risky business, this angel investing business. And that's been kind of since the Jobs Act was enacted, that's been the big criticism of it, is people are not going to appreciate just how risky investing can be. And I remember being back in 2012 doing panels on this and sitting on big groups with other lawyers who were just completely freaking out over this. There's going to be bloody shirts. The SEC is going to go nuts. We're all going to jail. Things have turned out, and I figured that eventually we'd get technology solutions that would solve a lot of these problems. And I think that's been generally true. But I want to start, before we get into this, with, I don't know if you saw it, did you see the New York Times article that came out last month, not that long ago, end of January? Won't say who they were talking about, but it was on crowdfunding and on the new rules and how they're working out. And they interviewed, might even be here, the founder of one of the big sites, the big Title III sites, who said he turns down a lot of deals, turns down a lot of companies. He vets them and he turns them down. But not everybody's turning them down. They go from his portal to another one. And there's one that got shut down by regulators after raising $5 million. It was turned down by one of the first ones. So it's risky business, and these people and it's creating some real issues. And in particular, the New York Times kind of seized on it. It wasn't a Title III deal, but there was a portal that was shut down recently. FINRA shut it down and I'm going to get into that a little bit later if I have time, for just simply not doing its diligence, not complying with the law, not checking out these companies, not vetting them. There's another one, I'm sorry, that was a Title III platform. There was another company that was a 506C, company that listed under 506C. Again, I don't want to mention any names, but turned out to be, so we're seeing these, turned out to be a total fraud. So, I'm sorry, not a total fraud, but a total loss. In other words, the company just didn't succeed, which is what happens to most of them. And, unsophisticated investors are saying, well, gee, why didn't you tell me that? I mean, I see that every day here in the Valley, where investors come in and they say, in the Valley, they're pretty sophisticated. They say they lost all my money. Well, that's just the nature of the game. But the newer investors, they come in and they say, they lost all my money. I want to sue them. So that's the challenge that we have. So with that, Fiona, why don't we, well, I got the clicker, kind of get into a couple of these things. I want to, Oops, did I mess it up already?
Just announce that.
Are we able to put this on slide share mode? Okay. So kind of getting back to the basics. Are you able to put that on slide share mode?
We were.
Maybe I can do it from here. Nope. Skype. So I think we all understand what the Jobs Act overview is, certainly by now. We've done several of these programs now. Before, we used to spend a lot of time, really going through a lot of the basics of this. And I don't know, given the time, that I want to do that. But I do want to pause on one aspect of this. if I can get this to work. So key provisions, we all understand that, okay, there go my slides, that since May that we've gotten, that we've gotten regulations. You've talked to a lot of the companies that are actually doing this. So I think it's worth doing an example so people understand just what these limits are. By the way, I'm violating all of Gene Massey's rules here with my slides. I know that already. There's way too much information on there. That's what happens when you get lawyers write slides for you. But there's an example in the regulations that I thought was really helpful as to exactly what this means in terms of the limitations on investments. So in the example, we had an investor who has annual income of $30,000, a net worth of $105,000. And the question is, how much is their investor limit? And this is, as you know, an investor by investor limit. And remember, it's greater of $2,000 or 5% of their annual income. So it's really kind of a confusing thing to memorize till you see the example. So in that case, $2,000, right? Because 5% of 30,000 is 1,500. It's worthwhile taking a look at that if there's any confusion at all as to what the limits are. Now let's get to something that you might not know. Did we?
It's not working now?
Okay. Fiona, why don't you walk us through a few of these, and I'm going to pause on the ones that I think are worth talking about.
Okay. So as you may already know that if you're being offering a crowdfunding offer, you must have an intermediary, what we call the funding portal, who must also register with the SEC and FINRA as a broker and dealer. And all those crowdfunding offers must be conducted through one of the funding portals. There are, of course, a lot of requirements and reporting issues on both levels, both the funding portal level as well as the issuers level. So for the intermediary, as I just said, they must register as a broker and dealer, and there are also other registration requirements under FINRA. And then for a concurring offer, one company can only use one intermediary. That means you cannot at the same time make the same offer on multiple funding portals. Although for the past years, there are several companies who conducted multiple issuer and through different funding portals, or maybe even issue different kind of securities. And that's okay as long as you carefully monitor all the offering conducted for the past 12 months that does not exceed the 1 million limitations. And there are limitations on the entities who can be intermediaries, and there are also limitations on what type of activities those kind of intermediary can do. If you go to the SEC's website, they actually published a couple of guidelines, both for the intermediaries as well as for the issuers, and they have a very clear list about what activities are considered safe harbor that the intermediary can conduct it, and what activities is absolutely prohibited for unlike a funding portal. The others.
Let's pause on this bad actor stuff, because I think that's really significant, the way that plays out. So Rule 503 of the regulation, it has a bad actor disqualification that disqualify offerings if the issuer or covered persons have experienced a disqualifying event. And covered persons is pretty broad. It not only means the issuer, it means its directors, its officers, it means beneficial owners of 20%, it means promoters, it means anybody compensated for soliciting the investment. So think about the diligence you're going to have to do as a platform on all of these people. And what are disqualifying events? Certain criminal convictions, court injunctions, restraining orders, final orders, SEC disciplinary orders, suspension from FINRA, SEC stop orders, even U.S. Postal Service false representation orders. So just think about the expanded diligence that has to be done. And that diligence is important. Did you want to spend any more time on any of these? Because I do want to mention this, because there has been a suspension an enforcement action of a portal that you're probably aware of, and it basically came down to really the diligence, because the funding portal should deny access to the platform if it has a reasonable basis to believe that it presents a potential for fraud. That's Rule 301C2. This portal was found not to have denied its access, and they had a reasonable basis to believe that. Rule 200C prohibits funding portals from including information if it's untrue. FINRA found that this portal had violated that rule. So there was an expulsion. So it's really kind of interesting that the portals, the issuers, the investors, I mean, everybody involved, including the lawyers, significantly, and I want to get to that, really have these obligations and some real responsibilities in this space to be good gatekeepers. And we've already had one kind of high-profile enforcement action already. Okay, why don't we move ahead a little bit. You know, I really do want to get to Reg A. So, is there anything else here? Issue or, let's pause on this. Can you talk a little bit about the disclosure requirements? Because I found this to be quite, I don't know if it's confusing, but there's a lot to it.
Right, so it's always confusing from the SEC side. So if you are registered with the SEC as an issuer, then first of all, you must file Form C, I believe before 21 days before you start offering the securities to the public. And then after that, you must file an update Form C, which is Form CU with the SEC within 5 days. To disclose how much investors you guard, and also for how much offers you got, and also other milestones you reached must be reported through Form CU. And then for the issuers, you generally you have an annual SEC report requirement, but there are like some exceptions maybe apply if you doesn't have enough assets or doesn't have enough recorded holders. Then you may be exempted from the annual reporting requirement. But once you started file the annual report, then even if you're qualified, it's not automatically go away. You have to file another form to terminate the annual report obligation with the SEC.
I'm going to jump ahead a little bit and talk about what's coming. I don't know if we talked today or yesterday about the Fixed Crowdfunding Act or the Crowdfunding Enhancement Act, but as we get into this more and more, you can see that the compliance burden is high, the diligence burden is high. From my standpoint, the liability burden is just way too high, but there is legislation that would change all that. A couple of significant things, the liability issue. Right now there's an enhanced Section 4 liability, 4AC liability they call it, for people involved in Title III crowdfunding. It's more than a lot of lawyers are willing to accept, and a lot of parties.
And that including a lot of people, not just the issuer, the directors, officers of the issuer, and anyone who's selling or promoting the issuance is also subject to the extended liability.
So that will likely be loosened up now that we've got a Republican Congress and a Republican president. The other thing is this prohibition of SPVs. You know what I mean by that? Special purpose vehicles. Right now, every investor, and this is Reg A Plus as well, has to be on a cap table. It's kind of not the way we usually do business in Silicon Valley. We like to put together, I like to form these little LLCs that all the investors invest in and have the LLC invest, so we got just one investor to deal with instead of 100 dogs and cats. That's not currently allowed, but there's legislation that would allow that, and that would make this a whole lot friendlier, I think. I want to talk a little bit about the data. Fiona, why don't you recite some of these stats for me?
So we don't have a lot of data because both the crowdfunding rule and the Regulation A was taken into effect in May or June or May 2016. So for the, right, am I right? So for the past half a year or 2015, I may remember it wrong. Right, the crowdfunding, the Title III was effective as May 2016, and Regulation A was summer 2015.
What I'm getting from this is not a lot of deals have been concluded. It's a little too early. But the thing that really kind of gets me about this is the compliance rate. You know, these rules, they're just not being complied with. As far as I can tell, it seems like not a lot of these companies are filing the forms that they should file. So that may be a regulatory issue. You know, maybe we need an executive order withdrawing regulations or something, or I don't know, maybe it's a company issue because there's just not enough money in these deals to justify the compliance costs. But I think that's something that's going to have to change in the future, and probably will. The other thing I want to mention is the type of security. Look at the type of security. If you can see the color codes on here. This agreement for future equity, which has been a lot of these are common stock. So in my world, you never sell common stock to raise money. It's a bad idea. It screws up your cap table. It means you can't keep your common stock really cheap so that you can reward your optionees with it. It's not the case with these crowdfunded companies. They're selling a lot of common stock online. I much prefer if they use the SAFE, the agreement for future equity. That's simply a warrant, simply a convertible or a derivative. It's an agreement to give somebody preferred stock in a later round or some other type of stock. But it kind of jumps out at me to see how much common is being used in these deals. That tells me that these are companies that don't plan on maybe doing institutional financings down the road. Let me jump way ahead here. By the way, these slides are available. I passed out the ones I had, and we have a table around the corner if you want to get into all the rest of this detail. Reg A, just briefly, Reg A Plus in particular, Tier 2 Reg A. You all know what that is. That's the rule that allows somebody to do a little private mini IPO. They can raise up to $50 million. Again, we just haven't seen a lot of these deals. Our office has been through this a couple of times and turned out it just wasn't worth the trouble. And if you look at just the statistics, not a lot of these have been filed. And I don't know, Fiona, do you have a viewpoint as to why that is and what's going to have to change for this to work? I think what it is, it's just the compliance costs are a little too high. It's a little too much work. It's almost the same as doing an IPO. You know, we've got a good chart here that kind of tells you like how all of these offerings differ in very important respects: state regulation, federal preemption, the amounts to raise, solicitation, advertising, disclosures, and we kind of go through all of these. And this is on our website as well. What I would like to just close on here is what's going to happen in the future. And it's really interesting. You know, there's a new sheriff in town, and I remember being at the SEC offices when the 506C regs were finalized, and I just know what the attitude of the SEC was towards crowdfunding generally, and you do too, right? Everyone's heard about it. Well, now we got a new sheriff in town. You know, Jay Clayton. He's a lawyer. He's a partner of Sullivan Cromwell in New York City. He is not generally known as a crowdfunding expert. He's known more as a very good practical business lawyer. And I have a sense that we have a chairman now who's going to be a lot more receptive to these ideas, just given the way the administration is going. And we might see a little bit friendlier rules and regulations. Also, we don't have a slide on this, but I do want to mention, since I got my crystal ball out and I'm telling you what's happening, this Supreme Court appointment is kind of significant for us as well, because this is a judge. We now have a Supreme Court that is not going to give the deference to regulations that courts have in the past. I don't know if you've heard of the Chevron test. That's the thing we've all been living with for several years, that gives regulatory agencies quite a bit of discretion as to how they make regulations. We've got a judge who might actually overturn that. More importantly, there's also probably going to be some lawsuits coming up on class actions, because that is kind of one of the things that scares securities lawyers everywhere, is the idea of a class action. In other words, I've been harmed by $100, but everybody else in the world has been harmed by, $10 million, so now there's enough money in it for us to get a lawyer. Well, we've got a judge that has historically ruled in favor of limiting class actions or making it more difficult to define classes. So I just expect you're going to see case law as well as legislation, as well as regulations that are going to kind of address all these little pain points that we've hit going through, and will make this a much more friendly environment going forward. Okay, I did not get into the detail of Reg A, but I don't want to stand between you and happy hour and those drinks outside, so I think I'm just going to call it a day, unless Sydney has anything else for me. All right, thank you very much.